The judge presiding on the Mar-a-Lago classified documents case is facing a lot of criticism from legal experts for holding multiple hearings on extraneous issues. Many have already been decided by higher courts or so minor they should have been turned over and disposed of by magistrates. Case in point is today, a hearing where Judge Aileen Cannon is allowing outside advocates to testify. They're rarely, if ever, permitted to testify other than at the appeals court level. But this is the district court level. This, along with stunning reporting today from the New York Times that fellow, more senior judges had tried unsuccessfully to persuade Cannon to recuse herself from even taking the case because of her inexperience. All this has led to so many delays that it has been a full year since she got the case, and she has yet to even set a trial date, making it virtually impossible for a trial to be held before the election. NBC News Justice and Intelligence correspondent Ken Dilanian joins us from the courthouse in Fort Pierce, Florida. Also with us, former U.S. Attorney Barbara McQuade. So, Ken, what is happening inside the courtroom? This is going to be more than a one-day hearing, right? What have you heard from Judge Cannon today?
That's right, Andrea. Today is the first of 3 days of marathon hearings that, as you said, really illustrate why this case is taking so long to get to trial, because Judge Cannon seems to want to have a hearing on every matter of dispute, no matter how arcane, no matter how many times it's already been argued and rejected by other judges. And so today's hearing is about the question of whether Jack Smith's appointment as special counsel was unconstitutional under the Appointments Clause. And Donald Trump's lawyers argued that one of the issues here is that Jack Smith actually should be considered a principal officer, not an inferior officer. These are terms of art in the Constitution, and therefore he should have been Senate confirmed. He's wielding so much power, they're saying, that since he wasn't Senate confirmed, that's improper and unconstitutional, and therefore the whole prosecution should go away. Needless to say, the prosecution opposes that, but as you said, this afternoon, she's going to hear from more lawyers, outside lawyers, so-called friends of the court, who are going to argue before her on both sides of this issue. That is unheard of in a federal criminal trial. Legal experts say that's just not done. It may happen in appeals court levels, but it doesn't happen at a trial. And it's another example of why this is taking so long. Now, Judge Cannon has expressed some skepticism about, for example, an argument by one of Donald Trump's lawyers that Jack Smith has created a shadow government unaccountable to the Attorney General. But Judge Cannon is often skeptical about whoever's in front of her. It remains to be seen how she will rule. If she rules that Jack Smith's appointment was unconstitutional, that will have huge reverberations. Obviously, it will go up on appeal, but it will really derail this classified documents case even further, Andrea.
Barbara, is there going to reach a point where someone would step in from the 11th Circuit at some point? Because these are such extraneous issues, already litigated issues, and she's not using a magistrate, a very experienced magistrate who actually had done some pre-trial work on a related case on the search warrants, for instance, for those classified documents.
Yes, I think this case really demonstrates the immense power that federal judges have. They're appointed for life, and they are afforded a great deal of discretion. There's nothing really legally wrong with what Judge Cannon is doing. It is just highly unusual for all the reasons that Ken just said. I think that a decision that is adverse for the government is what it will take for them to have an opportunity to file an appeal. So if Judge Cannon should, for example, strike down the special counsel rule, or some of the motions that she's deciding next week, whether to amend Donald Trump's bond conditions to prohibit him from making threatening comments about the FBI, or the use of attorney-client privilege information subject to the crime fraud exception. An adverse ruling would then tee up an appeal by Jack Smith, and I think that is where he could request, or the 11th Circuit Court of Appeals could on its own decide we're reversing this decision and assigning it to another judge. I think until that happens, judges have immense discretion to be able to manage cases the way they choose.
And one of the issues that also came up just a couple of weeks ago was she was holding a hearing on jury instructions. She hasn't even seated a jury. She hasn't started the trial. And that's usually done either just before the trial or at the end of a trial.
Yeah, that was one of the most curious things that I have seen. You're absolutely right. Jury instructions is typically something that the parties address even after the trial starts. As the closing arguments are approaching, that's when those moments get litigated. But not only was it this very early view of this, it was the content of that order where she asked the parties to engage with proposed jury instructions about the validity of a defense by Donald Trump under the Presidential Records Act. That really, put my hair to cause my hair to stand up on my head, because there's nothing about the Presidential Records Act that provides a defense to Donald Trump. This is a talking point he has used, but the Presidential Records Act, it actually is very incriminating for Donald Trump, because the Presidential Records Act was passed in the wake of Watergate to make it clear that records belong to the people and not to the president.